1994 and a set of regulations. It has a council which you've heard is called ICAS or ICAS, which consists of nominees from the IOC and from the National Olympic Committees and from the IOC president. You've heard that Tansri Imran was a member of that council for many years. Now, CAS functions as an institution which is independent. This is a key part of it. Independent of any sports organization, and which provides services for sports-related disputes through arbitration and also through mediation. As a separate function, it sets up non-permanent tribunals for major events such as the Olympic Games, Commonwealth Games, Asian Games, and so on. That is a very different sort of dispute resolution, where you don't have time to deliberate, where decisions have to be made in 5 minutes. I have no personal experience of that. I believe Vinayak has, but it's something that I will leave for others. CAS has a panel of approximately 300 arbitrators from 87 countries, chosen for specialist knowledge of arbitration and sports law. And my colleague Vinayak is, as you've heard, one of the 3 Malaysian arbitrators on this panel. CAS operations are financed by the constituent bodies. And although parties to a dispute may be asked, and I think usually asked, to pay a share of the costs of the particular dispute, it's very substantially subsidized and surprisingly not as expensive as is generally believed. I've acted as counsel in 3 separate arbitration disputes before CAS, and I can personally vouch for the fact that you can get the services of literally world-class arbitrators at only a fraction of the cost which would be incurred under other arbitral regimes. I think this is partly because those distinguished arbitrators take on this role on a semi-pro bono basis, and maybe because of their interest in sport, they give their time to it. How does a case get to CAS? As you know, arbitration is a consensual process. A party, which may be an individual athlete, a club, a sports federation, an organizer of sports events, sponsors, etc. They can take their disputes to CAS, provided that the parties must have agreed or be deemed to have agreed to refer the disputes to CAS. Now, this is essential for any arbitration process. The agreement may be on an ad hoc basis. That's to say, when a dispute arises and both parties agree to take that dispute to CAS. But more commonly, cases get to CAS through disputes involving sports federations, where the rules provide as a final level of appeal to CAS for settlement of the dispute. So typically, the constitutions which govern the individual sports or at international level will provide in their constitution, which will be binding on the national level committees, for reference to CAS as the final level of appeal. And of course, this is where the opportunity for Malaysian lawyers comes in, because if you're representing a national sports body, you get into disputes with the international counterparts or with other constituent members of that sport, then then ultimately the ultimate level of settlement of the dispute will be CAS. So you'll find typically in the international body, in the rules of the international body, there will be a rule which says that CAS is the final level of appeal. The organization of CAS, it's composed of two divisions. One is what's called the ordinary division, which deals with disputes at first instance, and the appeal division, which typically deals with appeals from decisions of national sports bodies, and then gone via the final level of appeal to CAS. Interestingly, the Constitution of CAS also provides for CAS to give advisory opinions on any legal issue concerning the practice of sport or sports-related activities. Any such opinion, of course, will not constitute an award. It is in no sense binding of the parties. But I think it is something that we can look at in Malaysia, because if you have a dispute which is of general importance, you can actually ask CAS to give an advisory opinion from a totally independent body. In one of the cases that I've handled, we were able, by agreement of the parties, to actually organize a leapfrog process, which enabled the parties to bypass the domestic appeal procedure of that particular sport and then go straight to CAS. This can be a useful step when both parties are determined to take their dispute to the highest level, and to save time, both parties agree and can leapfrog and go straight to CAS. This avoids the difficulty which arises when you are in among the high officials of that particular sport. There's always a lot of conflicts of interest, and it's quite difficult to form panels to settle that dispute, because everybody has some sort of conflict. So the leapfrogging process, I think, is something that could be encouraged. So what is the procedure like? In my personal experience, the procedures are refreshingly simple and informal. Counsel will be asked to choose the names of either 3 or 1 arbitrator from the panel of arbitrators whose names are supplied, and whether they want 3 arbitrators or a single arbitrator. And then the appointment will be made. CAS will appoint a case counsel within their organization to liaise between the parties and the arbitrator. Although English is not one of the Swiss national languages, all the correspondence and submissions that I've ever been involved on, everything is accepted in English. So that's not a difficulty. And then, in all 3 of the cases that I've handled, the arbitration was actually conducted on a documents-only basis. Where this is possible, so where you can decide the case without actually having to call witnesses, it goes without saying that apart from the huge cost saving, there's also a huge saving at stress level as well. So actually, the whole process can be conducted without leaving your own office. Where witnesses are required, then there has to be a hearing. It's a different matter, but it's a great step forward. Because of the arrangement between CAS and KLRCA, you should now be able to bring a Malaysian dispute which will be physically handled in KL, and of course then vastly reduces the cost level. Now, a word about the applicable law. As CAS is based in Switzerland, Swiss curial law will apply, but the applicable law for the merits will be determined by the parties on conventional principles, and if not only if not agreed, Swiss law will apply. In two of the cases that I've done, we've had a British arbitrator, very high standing, and in the third one, a Swiss arbitrator. And Switzerland, of course, as you all know, is a civil law country. However, in the field of international arbitration, I think due to the influence of the UNCITRAL model law and the New York Convention, there really does not seem to be a vast difference of approach between civil and common lawyers. It's not such a major difficulty that as one would perhaps think might be the case. CAS rules allow for a party to represent himself or to be represented by anyone, not necessarily a lawyer. So it's absolutely open. What happens when a law other than Swiss law has been designated as the law determining the merits? I'll just touch on this subject because I had to deal with this on a recent occasion. If you look at the Lord Mustill in his textbook Commercial Arbitration, he says this about that situation. It is no part of the arbitrator's function to multiply trouble and expense by suggesting that the two laws may differ. The party who alleges that foreign law is different from English law has the onus to state precisely what the difference is and to prove the relevant foreign law through expert evidence. And if he doesn't do so, the arbitrator is entitled to apply his own the law of his curial law. This of course is what Lord Mustill, very revered person of the arbitration